Mr. Sellon, we need to speak with you about a federal grant contract awarded through this district. I figured this was about the school improvement grant. What's the concern?
This is Paul Sellon, the superintendent trusted to spend federal money meant to lift one of the most underfunded schools in Nebraska. He operated without oversight for nearly 2 years, and not one person checked where the money actually went.
We've developed evidence suggesting payments connected to that contract benefited you personally. I don't agree with that characterization. I'd like to hear exactly what you're referring to.
He had spent his entire career inside school buildings. He would spend the next 2 years inside a federal prison. Within 18 months, agents from the Federal Bureau of Investigation would seize his contracts, his bank records, and the consulting invoices that documented every transfer. $314,121. Federal stimulus money, earmarked for one of the lowest performing schools in the state of Nebraska. A school sitting on the Santee Sioux Nation reservation. Money that was supposed to reach reservation classrooms. Money that landed in a family business instead. Before we go any further, I have to ask you something. If you found out the person in charge of spending federal money on a struggling school had pocketed nearly half of it, what would you want the sentence to be? Drop your verdict in the comments. And if you're new here, subscribe. We cover accountability stories the mainstream press lets slip through every single week. Paul Douglas Sellon was born in 1956 in a small town in southwestern Iowa, the kind of town where the elevator and the school were the 2 tallest buildings, and everyone knew who farmed which quarter section. His father ran cattle on rented ground and worked part-time at the co-op. His mother was a bookkeeper for a local implement dealer who handled small green tractors and kept a ledger by hand long after computers showed up at the bank. Money was tight, but never desperate. The family ate what they raised, drove what they could keep running, and treated education like the only ticket out of the kind of farm work that broke a man's back by the age of 50. He was the kind of kid teachers wrote up as, quote, dependable, end quote, in their evaluations. He turned in assignments on time. He read more than the other boys his age. By the end of 7th grade, his English teacher had written in the margin of a report card that Paul had, quote, real promise if he keeps applying himself, end quote. His parents tacked that report card to the kitchen wall and left it there for years. He graduated from a consolidated rural high school in 1974 with a class of 41. He played defensive tackle on a football team that lost more than it won, and ran the school's small student council the year a referendum nearly closed the building down. He saw, even then, what happened to a town when its school closed. The students didn't transfer. The families left. He enrolled at a regional state college in southwestern Iowa that fall, paying the tuition with a patchwork of farm savings, a small academic scholarship, and summer work hauling grain at the elevator. He chose education as his major in his sophomore year. He chose it because, by his own telling later, he had grown up watching teachers and superintendents matter in a way that bankers and lawyers never did in his town. He met the woman who would become his wife in his junior year. She was studying business administration. They married the summer before his student teaching year. He was 21, she was 20. His first teaching job was a 5th grade classroom in a town of 700 people on the Iowa-Nebraska border. He made $8,100 his first year. He coached junior high boys basketball as an extra duty for an additional $300 annually. His evaluations from those years described him as, quote, consistently meets expectations, manages a classroom with calm authority, demonstrates strong organizational skills, end quote. He earned a master's degree in educational administration through summer coursework at a state university across the river in Nebraska. By 31, he was a junior high principal. By 38, he was a high school principal. By his mid-40s, he held his first superintendency, a small district with 1 elementary, 1 secondary building, and a combined enrollment of 280 students. He was, in the careful language of the small district superintendent world, a known quantity. He served on the board of his Regional Administrators Association. He attended the state convention every January. He kept a list, in a small leather notebook, of every superintendent vacancy that opened up within driving distance, marked with the enrollment count and the salary band. He and his wife settled in Hamburg, Iowa, a Missouri River town in the southwestern corner of the state with a population of just over 1,000. They bought a 2-story house on a tree-lined street where the neighbors waved without looking up, and the school bus stopped at the corner. They opened a small side business together, a limited liability company registered through the Iowa Secretary of State that did property management and short-term equipment leasing. His wife handled the books. He signed off on the contracts. It was the kind of operation 1,000 small-town couples ran on the side. A second checking account, a second tax return, a second set of expectations. By the time he turned 56 in 2012, Paul Sellon had been a public school superintendent for 14 years. He had a master's degree, an administrator certificate that had been renewed 3 times, and a reputation across the state line as a man who could turn around a struggling district. That was the reputation that brought him north into Nebraska. To a school district most superintendents in his career bracket would never have applied to. A school district on the Santee Sioux Nation Reservation, in the far northeastern corner of Knox County, Nebraska, on a bluff above the Missouri River. The Santee Community Schools District served roughly 300 students. It was one of the lowest performing schools in the state of Nebraska by every measurable index: test scores, graduation rates, teacher turnover. The district had cycled through 4 superintendents in 7 years. To understand what Paul Sellon did, you have to understand the system he was hired to fix and the federal money that came with it. The Santee Community Schools District sat on the Santee Sioux Nation Reservation, an indigenous nation of roughly 900 enrolled members on a 40,000-acre reservation in northeastern Nebraska. The school district was a public school system funded by the state of Nebraska and the federal government, but the students who walked its hallways were overwhelmingly Santee Sioux children. The community had been failed by a long line of outsiders: boarding schools in the early 20th century, federal Indian agents, state systems that had never seen the reservation as worth serious investment. The school was, for most families on the reservation, the single most important institution in their children's lives. In 2009, in the depths of the financial crisis, the United States Congress passed the American Recovery and Reinvestment Act, the federal stimulus. Among the dozens of programs funded by that law was a dramatic expansion of the School Improvement Grant Program, administered by the U.S. Department of Education. The program had a single purpose: to pour federal money into the schools that had performed at the bottom of every state's accountability rankings, the schools that had been left behind for so long that no normal level of funding could move them. Schools exactly like Santee. The grants were enormous by reservation school standards. A district like Santee could qualify for hundreds of thousands, even millions of dollars over a multi-year cycle. The money was meant to pay for transformational reforms, new curriculum, extended learning time, intensive teacher training, reading specialists, math interventionists, the kind of high-priced, evidence-based support that wealthier districts had been able to buy for decades. The federal money came with a long list of strings. The grant required documentation, quarterly reporting, audited expenditure ledgers, approved vendors, outcome measurements. But the grant did not come with a federal monitor sitting in the superintendent's office. It came with the assumption that the people running these districts were, in fact, trying to fix the schools. And it came with one quiet, structural vulnerability. The superintendent of a small, isolated district was the person who decided which consultants got hired. The superintendent recommended vendors to the school board. The superintendent signed the contracts. The superintendent reviewed the invoices. The superintendent certified that the work had been performed. In a district with 300 students and a part-time business manager who also ran the front office, there was almost no internal check on the superintendent's contracting decisions. The Federal Department of Education was 1,800 miles away. The State Department of Education in Lincoln was 3 hours by car and not in the business of auditing every individual consulting contract a tiny reservation district signed with stimulus money. The school board was made up of community members, parents, and grandparents who trusted that the superintendent, the trained outsider with the master's degree, knew what he was doing with the federal paperwork. No one watched the contracts. No one checked the consultants. No one looked at where the consulting fees ended up after they cleared the consultant's account. The School Improvement Grant Award to Santee Community Schools, in the year Paul Sellon arrived, was substantial. The district qualified as one of the most persistently low-achieving schools in Nebraska under the federal formula. That meant a multi-year award with the kind of zeros at the end that the district had never seen before. One of the largest single line items in the grant budget was for outside consulting services. The grant called for an experienced educational consultant to design and implement the school's turnaround model, to work with teachers on curriculum, to coach administrators, to bring the kind of expertise a 300-student reservation district did not have on staff and could not realistically hire on a permanent basis. The contract Paul Sellon steered toward an outside educational consultant was for roughly $683,000. $683,000 federal dollars. Stimulus money, aimed at a reservation school where children sometimes shared textbooks, and the building's roof leaked through 3 classrooms when the spring storms came. The consultant was a man with credentials in the field. He had worked in school improvement before. He had a small consulting practice. He had not previously worked with Santee. He came in, like outside consultants do, through a relationship in the small world Nebraska education community. He knew Paul Sellon's name. Paul Sellon knew his. The conversation happened early, before the contract was finalized. Investigators would later describe it in the dry, careful language of federal court filings. Sellon told the consultant that to be hired, to get the contract that would amount to roughly $683,000 of school improvement grant funds, he would need to pay back a portion of the proceeds to the superintendent personally. The consultant understood the message. He believed, based on the conversation, that he would not get the contract if he refused. He agreed. That was the deal. Pay to play. Federal money for reservation children, conditioned on a personal kickback to the man who controlled the contract. The mechanics, once the deal was in place, were almost mundane. The consultant submitted his invoices. The district paid them out of school improvement grant funds. The consultant received the payments into his consulting business account. And then, in installments that tracked with the payments, the consultant transferred a portion back. Not to Sellon's personal account, where the transfer would have been visible to anyone running a routine financial review. The money flowed instead to businesses Paul Sellon co-owned with his wife. The same property management and equipment leasing LLCs he and his wife had registered in Iowa years earlier. Over the course of the contract, from 2012 into 2013, $314,121 flowed from the consultant back into the Sellon family businesses. Nearly half of every grant dollar that left the district's bank account for that consulting contract was kicked back to the superintendent. Federal stimulus money intended for reservation classrooms was being routed through one consultant into a property management LLC and an equipment leasing LLC in southwestern Iowa. The paper trail was, on its face, defensible. The district had a signed contract. The consultant had submitted invoices. The consultant had performed at least some of the work described. The board had been told what the consultant was being paid. The state had been told what the consultant was being paid. The Federal Department of Education had been told what the consultant was being paid. What no one had been told was the side agreement, the precondition, the handshake that had preceded the signed contract, the understanding that the consultant would get the work only if a piece of the work came back. While the kickback was running, the school it was supposed to lift continued to struggle. Teacher turnover stayed high. Test scores moved at the margins. The community kept doing what it had always done, trusting that the federal money would, eventually, reach the children whose names it had been sent to help. No one in the community knew, in 2012 or in 2013, that nearly half of what the district was paying for outside consulting expertise was being quietly redirected to a side business in Iowa. No one looked at the contracting decisions. No one asked the right question. No one noticed. No one checked. Federal money leaves fingerprints. That is the simplest way to say what eventually undid Paul Sellon. Every dollar of school improvement grant funding that passed through Santee Community Schools left a record in 3 places at once: in the district's books, in the consultant's books, in the federal grant management system that had to certify the spending. 3 sets of ledgers, 2 outside agencies, and 1 obligation to the United States government that the money had been spent as promised. The Federal Bureau of Investigation has a small but persistent presence in matters involving federal grant fraud, particularly when the grants involve Indian country. The Santee Sioux Nation is a sovereign nation under federal trust responsibility, which means that anything involving federal money and reservation institutions sits squarely inside federal jurisdiction. There is no county sheriff with first crack at it. There is no state attorney general waiting in line. Federal grant fraud on a reservation is a federal case from the first phone call. The phone call, when it came, started with grant spending irregularities. The exact source of the original complaint has never been made public in the kind of detail the case file would otherwise contain. What is known is that by the middle of the decade, FBI agents from the Omaha field office had opened an investigation into how Santee Community Schools had spent its school improvement grant funds. The agents pulled the district's contracts. They pulled the consultant's invoices. They pulled the deposit records on the consultant's business account. And then they followed the money out the other side. The pattern was visible almost immediately to anyone trained to look for it. Payments from Santee Community Schools to the consultant. Transfers from the consultant in tracking amounts to LLCs registered to Paul Sellon and his wife. The dates lined up. The amounts lined up. Nearly half of every contract dollar the consultant received from the district found its way to an Iowa business address. The consultant was contacted. The consultant, faced with federal agents and bank records that showed exactly what had happened, did what a man in that position is usually advised by a lawyer to do. He cooperated. He sat down with agents. He described the conversation that had preceded the contract. He described the moment Paul Sellon told him, in substance, that the consulting work would not come his way unless a share of the money came back. He described his belief that refusal would have meant losing the contract. He laid out the structure of the kickback in his own words. We are about to head into the federal investigation and the courtroom. If you have stayed with me this far, you already know this is not the kind of story most outlets bother to cover. Subscribe if you want to see how the federal system handles a public school superintendent who treated a reservation school's grant money as a private revenue stream. We do this every single week. The investigation that followed was methodical. Federal grant fraud cases of this kind are rarely won by dramatic confrontation. They are won by paper, by matching deposits to withdrawals, by aligning invoice dates against transfer dates, by walking a federal jury, if it comes to that, through a sequence of bank records that tells a story even an accountant could follow. Agents from the FBI's Omaha field office, working in coordination with the U.S. Department of Education's Office of Inspector General, assembled the case. They subpoenaed the consultant's bank records. They subpoenaed the records of the LLCs registered to Paul Sellon and his wife. They pulled the contract file out of the district office at Santee Community Schools. They pulled the grant award letters from the State Department of Education and the Federal Department of Education. What the record showed, when laid out in chronological order, was a clean pattern. Grant funds arriving in the district account. Payments to the consultant, dated against the consultant's invoices. Deposits into the consultant's business account, in amounts that matched the district payments. And then, in installments that followed within days or weeks, transfers out of the consultant's account into the Sellon family businesses. The total, when the agents finished the arithmetic, came to $314,121. Nearly half of every dollar the district had paid the consultant under that one consulting contract. Money that had originated, every cent of it, in the American Recovery and Reinvestment Act. Stimulus money meant to help a school on a reservation in northeastern Nebraska improve. The agents interviewed teachers and staff at Santee Community Schools. They interviewed school board members. They interviewed the part-time business manager who had processed the consultant's invoices. None of those interviews produced a single witness who had been present for the original conversation between Paul Sellon and the consultant. That conversation, the foundational pay-to-play conversation, had happened between two men in private, without a third person in the room, without a recording, without a written agreement. But the consultant's account of that conversation, combined with the bank records that showed exactly the kind of split he had described, was the case. There was no innocent reading of the deposit pattern. Consultants do not, as a matter of routine business practice, route nearly half of a contract's proceeds to a small Iowa LLC owned by the superintendent who hired them. The pattern only made sense in one direction. The pattern only made sense if the kickback was real. The federal grand jury convened in the District of Nebraska. The U.S. Attorney's Office in Omaha presented the case. The grand jury returned an indictment. The charge was theft of government money, a federal felony arising from the misappropriation of federal funds. The statute is straightforward: taking, converting to one's own use, or knowingly receiving federal money that one was not entitled to receive, carries serious federal time when the dollar amount climbs into the hundreds of thousands. The confrontation, when it came, did not look like the confrontations from other episodes on this channel. There was no body cam moment in a school parking lot. There was no patrol car at the curb. Federal grant fraud cases do not usually end that way. They end in a conference room in a federal courthouse, with attorneys on both sides and a defendant who has known, for a long time, that this day was coming. Paul Sellon retained a defense attorney. His attorney met with the United States Attorney's Office. They went through the evidence. They reviewed the consultant's statement. They reviewed the bank records. They reviewed the LLC filings. There was, on the defense side, very little room to maneuver. The pattern of transfers was not in dispute. The amounts were not in dispute. The structure was not in dispute. The only question, in the end, was what Paul Sellon would do about it. He chose to plead guilty. A guilty plea to a single count of theft of government money in the District of Nebraska, with a stipulated loss amount of $314,121. The plea agreement spelled it out: the grant funds, the consultant, the conditions Sellon had imposed before the contract was signed, the pay-to-play arrangement, the transfers into the family businesses he co-owned with his wife. Every element of the offense, admitted in writing, signed in front of a federal judge. In the change of plea hearing, the judge asked Paul Sellon, in the routine language of federal court, whether he was in fact pleading guilty because he was in fact guilty. Paul Sellon answered, in substance, yes. The court asked whether he understood the rights he was giving up. Yes. The court asked whether anyone had threatened him or promised him anything outside the four corners of the written plea agreement. No. The court asked whether he understood the sentencing range he was facing. Yes. That was the confrontation. A federal courtroom in Omaha. A signed plea agreement. A man who had spent his entire career inside school buildings, admitting, in open court, that he had taken $314,121 of federal stimulus money that had been earmarked for one of the lowest performing schools in Nebraska. A school on the Santee Sioux Nation reservation. A school whose children had never seen the money that the superintendent had quietly redirected into a property management business in Iowa. Sentencing was set for October 16, 2019. The pre-sentence investigation report had been completed. The probation office had calculated the federal sentencing guidelines range. The defense had filed its sentencing memorandum, asking for a sentence at the low end. The government had filed its response. The judge was Senior U.S. District Judge Richard George Kopf, a longtime federal judge in the District of Nebraska, known for sentencing remarks that did not pull punches. Judge Kopf had served on the federal bench since 1992. He had handled federal cases out of Nebraska for decades. He had handled grant fraud cases before. He had a clear view of what federal money meant in a place like Santee. The courtroom on the day of sentencing was not crowded. A federal sentencing in a nonviolent grant fraud case rarely is. The defendant, his attorney, the prosecutor, a representative from the U.S. Department of Education, a handful of family members, A reporter from a regional paper. No bank of cameras. No press scrum on the courthouse steps. Just the quiet, formal weight of a federal sentencing. The prosecution made its case for a sentence in the heart of the guidelines range. The harm, they argued, was not merely financial. The grant funds had been federal stimulus money earmarked for the lowest performing schools in the country. The harm was not just to the U.S. Treasury. The harm was to the children of the Santee Sioux Nation, who had been told that the federal government was sending serious money to help their school. The harm was to the trust the community had placed in a man with a master's degree and an administrator certificate. The harm was to every other reservation school that watched, from a distance, what happened when a school improvement grant was treated as a private revenue stream. The defense argued mitigation, a long career of public service, a guilty plea that had saved the government a trial, cooperation with the probation office, letters of support from former colleagues, the absence of any prior criminal history. The argument was, in the careful language of federal defense work, that Paul Ceylon had made a serious mistake at the end of a long and otherwise lawful career and should be sentenced accordingly. Judge Kopf listened to both sides. When it came time to impose sentence, he spoke directly to the defendant. He addressed the trust that had been placed in him by the school board, by the community, by the United States Department of Education that had wired federal stimulus money into a reservation school district, believing it would reach the children. He addressed the deliberateness of the scheme, the fact that the kickback had been baked into the contract from the first conversation, the fact that the structure had not been a moment of weakness, but a sustained arrangement that ran from 2012 into 2013. He addressed the choice. Ceylon had not been desperate. He had been a paid public servant with a comfortable salary and a side business. He had taken the money anyway. The sentence Judge Kopf imposed was 24 months in federal prison. 2 years. Followed by 3 years of supervised release. Restitution in the full amount of $314,121, payable to the U.S. Department of Education. The standard conditions of federal supervision. A self-surrender date to be set by the United States Marshals Service. The judgment of conviction signed and entered on the docket. 2 years in federal prison for the man who had been entrusted with the federal money that was supposed to lift a reservation school out of the bottom of the state rankings. 2 years for the $314,121 that had been quietly redirected from a consulting contract into a property management LLC and an equipment leasing LLC, registered to him and his wife in southwestern Iowa. The restitution order followed him out of the courtroom. Federal restitution does not expire. It does not get discharged in bankruptcy. It runs for the rest of the defendant's life.